I'm here with Amy Bell from AML Sorted, who's been presenting an extremely interesting paper on the whole issue of lawyers' compliance with anti-money laundering, counter-terrorism financing legislation, which is abbreviated to AML CTF. Amy, you raised a whole lot of issues. I know you're very experienced in all of this, but let's start with the time frame. When is this legislation going to be introduced?
So the Act is already passed, although we are waiting for rules. There are already some rules, so we're waiting for amendments to those to bring in the professions, the lawyers, the accountants and the real estate agents. We have just finished a consultation on that, so hopefully we'll see rules before the end of the year. And the actual go live date is the 1st of July 2026, where firms that are in scope will have to have their programme ready to go.
Well, this is a property law conference you've been speaking at, and you pointed out that really all property lawyers are going to be affected in a major way about this because most property transactions will be in scope. One of the issues that comes up is risk management, and I was rather interested in your distinction in your presentation between client and matter when you're considering risk management. Can you explain that to us?
Yeah, absolutely. So you should consider the risk of money laundering, terrorist financing separately between the client. So the client could be a very ordinary organisation that is well established. But it could be doing some activity that could be money laundering, and that's what they're instructing you for. So it's important to assess the risk for the client, and then every time you're instructed for a matter to consider whether there are any factors for that particular matter that change your perception of risk.
So even a good client could have a bad matter, if you know what I mean.
Absolutely, especially a corporate. Corporates, the criminals will try to hijack existing entities and then use them for money laundering, and use the fact they've been operating for quite a while as a reason for them being assessed as low risk, but actually they're now going to divert the activities to that company for money laundering.
Now, another thing you mentioned in your presentation in the context of money laundering generally is the idea of layering. What do you mean by layering?
So what I mean by layering is it's commonly known as the second step of money laundering. So the first one is putting the criminal property, the dirty money, into the banking system. They don't use lawyers for that usually. They come to lawyers when they're trying to disguise that money by putting it through legitimate looking transactions. They do that a load of times. This is where the laundering washing machine kind of analogy comes from. It tumbles around, layers and layers are added, so it's really difficult to unpick and to figure out where the dirty money came into the system in the first place.
And one final question for you. You've pointed out that it's very difficult to really do too much in advance because we don't have the regulations. But is there anything that lawyers can be doing now to prepare for the introduction on the 1st of July 2026?
Absolutely. There isn't a one-size-fits-all AML program. It's based on the risk for your particular practice. And so what you can be doing now is starting to make observations of the types of clients you have, the types of work you do for them, the jurisdictions they're operating in, how much money they might be introducing through your trust account or through a different route like PEXA. Where might that money be coming from? Might it be savings? Might it be investments? And get an idea of the typical profile of your clients, so then you can assess what the likely exposure is to money laundering and terrorist financing.
Amy Bell, thank you very much. I'm sure we'll be talking to you again.
Thank you.